So let's give you guys a very important update. Because I haven't posted in about a week, this is one of the most important battles of the entire year that's happening right now. What I need you to understand is this. The defense has now been separated exactly as I told you, the federal agencies and the courts. The upstream parent companies up here and the downstream shell entities down here where the employees are placed. In the federal case, the same law firm representing all the shell structures is now in federal court representing more shell structures. The same law firm. And now they're trying to expand it, and let's not get into that right now. It's quite remarkable. Well, recently they just asked the judge for an extension, claiming that they were recently retained. Well, of course I opposed it because they weren't. They're a law firm that has been involved since April of last year. That's almost a year. Well, the judge granted the extension to February 6th, which they gave their motion to dismiss, and I have it in my possession. I can't go line by line with it with you because I still need to oppose it. But what I can say is this. It relies heavily on omissions, shifting positions, and contradictions. For an example, for over a year, they argued that all the other entities were not subject to arbitration, just a wage claim. Now they are trying to argue that they are. All the other parties should be subject to arbitration. Same facts, completely different position. What the heck? But here's one of the most serious issues. They attached an arbitration agreement as an exhibit to the federal court that does not match the original one, not matching the one that different courts have. The name identifying block is changed. They changed my name from my middle name to my last name without no one knowing about it. It is altered. Now, if one of you and I did that, we altered evidence, non-matching evidence into federal court, there would be immediate consequences, sanctions, credibility damage, possibly even worse, prison. Federal courts rely on the integrity, and that's not a casual mistake. Because of how serious this is, I filed a motion or a notice telling the court that there is altered evidence on the record so the judge can review it. You know, at the same time, Sanofi's defense firm, the defense firm for the upstream parties, walked back our agreement of an extension of February 11th and tried to get another extension, even though we agreed on a certain day. Interesting. Well, right now I'm preparing one of the most important oppositions that I have ever done in this entire year. This is it. And I'm preparing it against Fisher Phillips, and I need to win this motion. And Sanofi is about to file their motion to dismiss whenever that comes, and I need to oppose it perfectly. I cannot lose this case. So I'm ready to oppose their motion as well. What you're seeing right now is an attempt to stagger the deadlines. One law firm will file then the deadline will hit here. They don't have to file till then, so it just extends. Try and overwhelm me in the court and the narrative. Even simply submitting altered evidence with the court, with these three law firms being included, is incredible and is unprecedented, and I'm documenting everything. There's much more happening in arbitration and federal court that I can't just share just yet. I need to wait till they ripe and things, I can file things and all that, but I will keep you completely updated. This is insane. We have altered evidence in federal court right now.